Yes, any mention?
Please, Your Lordship, I beg to mention item number 11. The counsel for the petitioner is on leave. I'm appearing on behalf of the respondent, my lord.
On pre-made by the petitioner, list this matter after 2 weeks.
Was always. May it please, Your Lordship, I beg to mention item number 14 as well, my lord.
You are for respondent.
Respondent.
Who's for the petitioner?
I'm Chanda.
Have you sought his consent?
Your Lord, I've informed them, but then they are not. I called them up, but then they were not picking up my call, my lord. I'll be informing them, my lord.
So let the matter be called up.
Sure.
You can make your mention at that time.
Much obliged, your lord. From supplementary cost list, item number 1.
Yes, Mr.
Your Lordship, this is the joint petition filed by the petitioners, and the petitioners herein they are invoking the inherent power of this Honorable High Court under Section 482 of the CRPC, seeking for quashing of the FIR and other subsequent criminal proceedings. Your Lordship, the petitioners here, the petitioner number 1 is the accused person, and the petitioner number 2 is the complainant and the alleged victim in this case. Your Honor, the brief fact of this case, Your Honor, is that the petitioner number 1 is working in Uttar Pradesh, UP, before 2014 and 2014, during 2014. Then when she came back home, they are staying at Nongpo, so she invited petitioner number 2, who is her friend, like a relative, whether she is interested to go and work with her in UP. So she also expressed her willingness that she is interested. They are both at the very young age at the time. So on 12 May 2014, both of them traveled to UP. And it was the first time for petition number 2 to travel by train, and that also to go outside the state. And they were traveling by a general compartment. So while approaching Bihar, the group of third gender, which we usually nickname them as hijras, they are approaching them. And she could not understand a word of Hindi, this petition number 2. And they were asking money. So she could not understand, and she was not giving any tips to them. And then they start this verbal abusing, which is a very unwanted social behavior that is practicing that is usually happen in a country while traveling, especially by train. So because of that situation, she was so much in panic and fear that later on, after that situation, she fled away from that place. I mean, she ran away from the train. Then after she ran away from the train, the police found her because she does not know where to go. And when she was sent back to Shillong, when she reached Meghalaya, then she registered case an FIR in Nongpo police station. The FIR, I will take your lordship, page 14, FIR. She registered page 14. It's translated copy and type copy. Your Lordship, after she registered this FIR against the petition number 1. And after this FIR was registered, the case was registered as Nongpo PS case number 88 2014 and booked under section 365 and 420 of IPC, which means cheating and kidnapping. So later on, when this thing happened, then the family at all sit together and make her understand, and from the side of petition number 1 also, then she realized that it was out of panic and fear that this incident had occurred. Very unfortunate incident that she had gone and registered the case. So therefore, Your Lordship, they had entered into a compromise, and that compromise.
The FIR says otherwise.
This.
The FIR mentioned
Yes.
4 or 5 members of men.
Yes, Your Lordship. Actually, it is. It was she was mistaken. It's not correct. It was because of the. She was calling those people who are working there, but they are not coming. It was those not third gender. Actually, they came. They came inside. It's not that no, those people came and pick her up. So they have
Okay.
also.
This is when she reached Guwahati.
Yeah, when she reached Guwahati. When she reached Guwahati, they travel by themselves. Actually. She was the impression. She was in the impression that this petition number one had called those men. Actually, it's not very true. The fact is otherwise very different, and they had entered into a compromise. Your Lordship, that compromise letter.
What is the stage of the case?
The case is CC considering of charge. It is pending before the subordinate district council court.
Yes, Mr. Shule, anything?
This is Your Lordship. Lordship, I'll have to take instruction, Your Lordship. What is the stage of the proceeding? Because it is a 2014 matter.
Particularly look into the his diary,
Lordship, yes, I'll have to get that, Your
the
Lordship.
statement and the investigation, how it has gone.
It'll come after 2 weeks, Your Lordship.
Heard Mr. P. Dockwood, learned counsel for the petitioner. The respondents 1 and 2 have been duly represented by Mr. Indishwar, learned AAG. As such, no further notice is required to be issued in this regard. On premiered by the parties, this is matter of 2 weeks to enable the learned AAG to seek relevant instructions in this regard.
Apply, Your Lordship.
Much obliged.
If so required, the case diary or any relevant information may be produced before this court.
In the xerox copies, Your Lordship.
What? 0 copies.
Much obliged, Your Lordship.
See, nowadays it's very good you get this kind of display. Otherwise, you don't know. Either you have to telephone you or shout from the. Thank you.
supplementary cost list. Item number 2.
May it please your lordship. My lord, this matter came up before this honorable court also. My lord, in fact, there were 3 writ petitions concerning the same issue, my lord. So all those writ petitions were returned with the liberty to file afresh, and this is how this writ petition has come, my lord. Now the
What are
facts
the
of
changed circumstances?
my lord, no, with liberty was given, my lord, to file afresh. So,
Based on the same facts,
my lord,
circumstances.
same. That's what the previous order says liberty has been given, my lord. Because, my lord, earlier it was pending in 3 parts, so it would have been difficult, my lord. So just to, my lord, overcome that difficulty, my lord, it was written in file 6. Now, my lord, issue pertains to the appointment of CM of Millim, my lord. Here, my lord, challenge is to the acceptance of resignations of respondent number 6 and subsequent, my lord, holding of election whereby respondent number 7 was appointed. Now, my lord, the fact in brief is that in 2007, respondent number 6 was elected as a regular CM, my lord. And he functioned as such, my lord, till 2016 when a complaint was lodged against him. And basing on that complaint, my lord, he was placed under suspension. An inquiry was instituted, my lord. And to fill up that stopgate vacancies, my lord, the acting CMs were appointed. Now, my lord, so far as the appointment of acting CMs were concerned, there were dispute also, my lord, there are filing of cases. But this may not be very relevant at this stage, my lord. Now, what happened, my lord? When my lord, this entire issue was pending, the inquiry is going on, my lord. The respondent number 7 was functioning as an acting CM. The respondent number 6 tenders his resignation on the ground of his ill health, my lord, and the fact being he doesn't have a region also. And that resignation was accepted by the district council without reference to the inquiry pending against him, without mentioning anything, my lord. And thereafter, my lord, surreptitiously, my lord, by his different notifications, elections were held when the respondent number 7 has been appointed. Now, my lord, our contention here is that when a person is under suspension, my lord, and there are charges pending against him, which is pending inquiry, my lord, his resignation could not have been accepted. That means giving him clean sheet. So, basically, that makes this entire inquiry infructuous, my lord. Now, my lord, in addition to that, my lord, what happened? There stood a direction issued by this court, wherein it was directed a representation challenging the appointment of a respondent number 7 to be disposed of by the district council. The direction was made by this honorable court, saying that that representation should be disposed of within 3 months, preferably within 3 months of time. And it was with regard to the appointment of respondent number 7, wherein the allegation was made that respondent number 7 happens to be the own nephew of the respondent number 6. And my lord, the contention was raised that since there are allegations, especially allegation of financial embezzlement against number 6, so if respondent number 7 is in the office, who is his own nephew, my lord, that may hamper the inquiry. Now that during the when this representation was not disposed of, the petitioners herein approached this honorable court. Now this honorable court, my lord, by the direction, my lord, dated 14/10/2022, my lord. That is at page 12, if lordship. Annexure 12, my lord, page 80. Sorry, if lordship comes with.
Yes.
Now, my lord, heard Mr. So and so, my lord. Upon hearing the parties, what is understood is that the grievance of the petitioner is with regard to the representation dated 2/6/2020, filed before the executive committee in charge Ilaka, KHDC Shillong, wherein the petitioners are in the know as regards as the inquiry conducted against the CM of Millim, Sri Latho Manik CM, and the presence of the acting CM of Millim, who is own nephew of the suspended CM, is considered improper under the circumstances. Accordingly, by the said representation, the executive member in charge Elaka HDC Shillong was approached with a prayer to remove the said acting CM during the pendency of the inquiry. As submitted by the parties, this court may not go into the merits of this petition, but suffice is to say that the representation in question is required to be disposed of expeditiously by the authorities concerned. On this premise, this matter is hereby disposed of with a direction to the respondent KGC to dispose of the said representation dated 2/6/2020 within a reasonable time, preferably within a period of 3 months from the date of this order. In view of the above, the petition is accordingly disposed of. Now, my lord, 3 months' time from my lord 14/10/2022, nothing has been done. And what happened, my lord? The subsequent, my lord, events, acceptance of resignation and all, my lord, basically has circumvented this order. My lord, I will go to say that is utterly contemptuous. And it basically, my lord, projects the malafide on the part of the respondents. So, my lord, what I am praying at this stage, my lord, notice may be issued to the respondents, my lord. My lord, I have filed an interim application also, my lord. Now, realizing that there is a lapse of time, they may be allowed to file reply there also.
You file continuation of delay?
My lord, I have filed an interim application here also.
So that has to be looked into first.
My lord, let them file a suppose in that. Let a notice be issued in that one also.
Then first we have to issue notice in this application.
Wait, please, Your Lordship. Your Lordship, I'm representing KHADC on behalf of KHADC. Your Lordship, we haven't received the brief yet.
Yes, notice to be issued to you.
Yes, from the office, Your Lordship.
Notice to be issued to you.
We have given them advance copy, my lord. Others, we have the acknowledgement.
Good that you have come.
No, we have given them notice, my lord. That is a requirement. So we have the acknowledgement, my lord.
Can you have any Miss case? Heard Mr. B. Versace, Senior Counsel, appearing for the applicants. This is an application. This is for this application is for this is for stay of the notification.
My lord, the main writ petition is for the purpose of staying the notifications. My lord, the letter of acceptance of resignation as well as the notifications of election and subsequent result.
But the election has already taken place.
Yes, it is over, my lord. It is over.
So it's over.
It is over. We are challenging the very legality of the election.
Exactly. You can do that. You can do that.
Right.
But there's no question of stay of his, his being in office.
No, we are asking the result, my lord. If we can, my lord, satisfy your lordship prima facie that this election was wrong, then the result that can be stated. So that is what we are asking. My lord, our interim petition is only with regard to that. But then our main writ petition is with regard to all the notifications.
Main case of the Kajuhito heard Mr. or Sadi letter counsel for the petitioners. As prayed for, let notice be issued upon respondents. The same returnable within 2 weeks. Main case.
My lord, my friend will be there to accept notice for response.
Or Miss Miss has accepted notice on behalf of the respondents.
KHADC.
125.
125.
125. Oblique KHDC.
For 6 and 7 we will take steps.
The respondent is petitioner is directed to take steps on for issue of notice upon the respondent 6 and 7 respectively. The same returnable within 2 weeks. This case on submission made by the Senior Counsel appearing for the applicants. This application will be taken up on the respondent being put to notice and on appearance of them and on their appearance before this court. This is matter is listed after 2 weeks.
Right.
Item number 3.
It was filed yesterday.
Maybe reserve.
Wish to
All of them filed.
All
to
the
file a
parties
rejoinder?
has filed. Yes, all the
All
parties
of them
has
filed.
I thought you wish to file a rejoinder to their
filed. No, not necessary. Not necessary, madam.
Leonard, Mr. KP Bhattacharya, Leonard G has submitted that the written argument on behalf of the respondent number 5 has been filed for this court. Who's respondent number 1? Union.
My lord, in different case, my lord, all connected matters, different respondent. My lord, may kindly record state respondent.
When is the party in the
State
amalgamation case only?
So I took respondent 5, I state respondent.
Yes, state respondent.
One is Union of India.
One is the, my lord,
CGS used to appear.
maybe vary, my lord, in different cases, my lord.
But he is not here.
He is not. He has. He said he will not file, my lord.
But you say that he said.
Last time he made a submission that he is not willing to submit the written argument.
But when the matter is is listed, he should have been here.
Yes, he is supposed to be. Just have a look.
It would, you see, it's proprietary demands that when the matter is there. This court has noticed more often than not, learned counsels are not appearing when the matter is called up. If not, if they are not available, you should have requested your colleagues. Yes, Mr. Demnat, where were you? Having tea? This matter is listed, you should have been there. Your submission is you are not finding any written argument.
No, because I understand we are not having the parties control of that.
Have you filed your counter affidavit?
No, it is.
Verbal submission.
So what is your stand then? Your stand has to be recorded.
So in this case, Your Lordship, no written statement is filed.
So what is your stand?
My stand is there, Your Lordship, that in this case, we are not having pervasive control over the society. So we are not having any role in this matter. And we are not the necessary parties.
If you are not necessary parties, then they should have made a prayer for striking of your name.
Should have filed an application for striking off.
Have they filed?
Never, for the last 5-6 years. Anyway, that is his case.
Once you are in the fray, you have to make a stand. And if you either side with the petitioner or there is the co-respondents, it's up to you. But you cannot say that I'm not a necessary party, therefore I will not do anything. You think about the court when the judgment is passed. Your presence has to be recorded as to what you have, what is your stand. That has to be there on record.
Your Lordship, in this respect matters, since beginning it is not filed, so at the best I can file one. But it is in the finally, when I entered in the final hearing, Your Lordship.
Should have said that, Mr. Hera. See, now this matter is at the back end. Now, if I don't allow you to, to make your submission, then the court will be accused. But you should have been responsible enough to state your stand, or make your submission. Oral submission is also allowed. Now you are not prepared. You don't know the facts of the case even. You come back tomorrow. You go through the matter. I'll hear your submission tomorrow.
So, Your Lordship, my submission here only with this much. That's we are not having any.
Okay. So you are making a submission now.
Yes, sir.
Then do it.
So this is the same submission because they are asking for these matters.
Yes.
That first of all, they request that some fund is given from some organization in the Assembly. This is a welfare fund. So welfare fund, when it is coming, and in these matters, Your Lordship, this Assam representatives have been no control over the welfares. They are the independents in the society. So if they given the fund to the petitioners' salaries and others, and even to the respondent Assam society, so there is no connection with the central funds or consolidated fund of Government of India. And another aspect of the matter, you will see, the school is situated in the premises of this Assam Rifle, this too, but it is given for the welfare of the Assam Rifle employees, their kids and others, and not only them, it is even the other people so they can study. So if it is even land is given to the established society, so it is does not constitute this, it is given from the Consolidated Fund of India. And moreover, for the activities whatsoever carried out by the Assam Rifle Public School, here in there, though one of the member is there from the Assam Rifle, designated person, but it doesn't constitute that this will be the society governed by the Assam Rifle. So this is the basic issues here. And subsequently, you see, when this employees of this Assam Rifle Public School, they have already hesitated before this honorable court under the 5th pay commission, because it is given that they will be given under the pay commission. So then pay commission is given. Then also Assam Rifle didn't come to the picture of it for making payment. It is given by the Assam Rifle Public School itself. And due to shortage of fund, they have borrowed the funds from some others or given some donations. So it has no connection with the Assam Rifle or with the Government of India, Ministry of Home Affairs. Because Assam Rifle fully is under the central government. And then if any funds come up for this Assam Rifle people, they are coming for the Consolidated Fund of India. But here nothing says in the record shown that any amount has come from the Consolidated Fund of Government of India. So having the namely this DGR is the one of the members of the society is given. So does not mean that he is controlling the whole society. So in this society, you cannot be said that it is the pervasive control of the Assam Rifle. So due to this, your lordship, this Assam Rifle is not a necessary party in this case, and it is in between the society and its employees. And moreover, another aspect of matter, your lordship, when this transfer took place, and policy of the transfer of the employee of the Assam Rifle Public School, nowhere it is there this Assam Rifle is controlling and any rules of the Assam Rifle is applicable. And this is the rules what are framed therein by the Assam Rifle Public School under the societies. They are having their separate rule, and they are governed by the Societies Act as well as the Assam Rifle Public School whatever recruit rule they have prepared for themselves. And it is not even constituted under 309 of the Constitution of India. Even the Assam Rifle not having any control about the management of the Assam Rifle Public School. So in view of the matter, your lordship, this Assam Rifle hearing, they are not having any purpose control in any matters, and as such, Assam Rifle is not the necessary party in the instance case.
Mr. Artemna Leonard CGC has appearing for the Union of India has submitted that no written argument will be filed on behalf of the said respondent. However, the oral argument advance would show that the Union of India, particularly the Assam Rifles, are not necessary party, is not a necessary party in this list, in as much as it has no pervasive control over the management of the said Assam Rifle Public School. Although the school would cater to the requirements and needs of the employees of the Assam Rifles personnel, cater to the needs of the employees and their children or wards. Thanks.
Including others, you see. Including others, even
Including
general
others.
public also can go.
Including others, including general public, including members of the general public. colleagues. On consideration of the submission made, the judgment in this case is hereby reserved.
3 to 7 minutes. Similar.
Item number 8.
Lordship, I pray the matter may come over the end of the board, Lordship.
End of the vote.
From duly causeless. Item number 1.
Lord, we have already filed a rejoinder, Your Lordship. This matter can come up for hearing in due course, Your Lordship, after 4 weeks, Your Lordship.
So the pleadings are complete.
Yes, Your Lordship.
Letter counsel for the petitioner has submitted that the rejoinder affidavit has been filed in this regard, in this matter. As prayed for, place this matter for hearing after 3 weeks.
Obliged, Your Lordship.
Item number 2.
Condonation of delay.
My Lord.
Condonation of delay.
My Lord. I have stated categorically
Respondents, all the respondents are here? You are appearing for all the respondents?
Only one respondent.
Only
Others
one.
have been able.
Okay. You just, yes, Mr. Khan, tell me, what are your sufficient cause for filing this?
My Lord, I have stated specifically at para 4 of my petition.
Yes.
I'd just like to read out it. In fact, that there has been, I would just like to start from para 1 so that the entire situation will be clear before the court. My Lord, what has happened that here the appeal was that the impugn order that was passed on 22nd 11/19 in the MSC case number 44, and subsequently it was numbered as so and so, along with the judgment dated 31st 1/22 passed in review. There was a review petition also thereafter, after the passing of the judgment application that was numbered as 120 by the learned member motor accident claim tribunal.
Review of the judgment?
Yes, ma'am. Now what has happened, there was a review because what has happened that when the award was passed, there was an extra amount of 10 lakhs rupees that was paid by the department, specifically mentioning the judgment that it was paid, that amount was paid resulting in the due to the accident. That was not an ex gratia amount. So that part was included in the judgment. Then we filed a review that there was apparently there's an error. But however, nevertheless, the tribunal did not interfere. Of course, that took long time. They said that no, the order is passed by the original order is correct. So the review was also rejected. We have come before this court to prefer the appeal against the original judgment as well as the review. So as a matter of fact, I have stated that basically in the paragraph 2 that the impugn order was passed by the tribunal bureau on 22nd 11/19, and subsequently the period of limitation started to run with effect from the date that is 23rd 11/19 till the filing of the application that is on 22nd 12/22, and that the review application was filed on 27/1/20, and it took another 66 days for the review petition to be filed. The civil court was closed for winter vacation from 22nd. Immediately, the same was immediately filed on the date of reopening of the law.
The review was heard only after
Yes.
Was disposed of after 4 days.
No, my lord. Review was disposed of after a period of that took around more than 34 days.
But here in your paragraph 3,
My lord, that the review application was filed on 27/1/22 and the same was heard and disposed of on 31st/1/22. Yes, clerical mistake.
so then we only have 5 days.
No, my lord. So far the review is concerned, that was filed on 20th. That's a clerical mistake. 20th. 2020. It's a clerical mistake. And then it was disposed of on 31st/1/2022 by the tribunal, dismissing the same, and that took 734 days. Now, basically, so far the review petition was concerned, that was the substantial part of the delay. Now, if we exclude that portion, it comes not more than, I have roughly calculated, it comes not more than 391 days, if you exclude the review part. Now, as per the, so far my explanation is concerned, in the para 4.
See, just a moment, sir. When was the original award passed?
22nd, 11/19.
22nd, yes, 11/19.
19.
Then you filed your review application on
27/1/20.
So that is after 3 months.
Well, there was a delay. You have mentioned.
Okay.
So that explanation has been given in para 4.
So if there has been a delay at all, before the review court, have you filed any application for continuation of that delay?
Well, what had happened that since there was a vacation, I have given my explanation.
Hey, let's assume. Let's assume that the since the review was taken on board, was heard, and was disposed of. So therefore, if there was any delay at all, that would have been deemed to have been condoned.
Condoned, madam. Okay. Yes. So I have mentioned that
as far as filing of this present appeal is concerned, you should take it. The period should be from 31/1/2022.
Well, yes. But nevertheless, I have taken from the date of the judgment.
I don't think that's necessary.
Yeah. So, but so far, article.
Let's take it 31/1/2022.
Yes.
Then, when was this appeal filed?
This was 22nd 12/22.
Oh, so
yes. I've taken at a stage. Once a time.
Therein lies the delay.
So there
for about 11 months or so.
Yes. So at paragraph 4, I have given the details that there has been a delay of another 325 days, with effect from so and so till 22, and altogether there has been a delay of 66 plus, that is before filing, and plus 734 days after the period where the review petition was pending, and then after the review was disposed, that is another 325. So altogether roughly comes to 125 minus the 90 days period. So I have given the explanation category in paragraph 7 of my petition, which so far the delay portion is concerned.
Yes.
So
please read out.
Just write paragraph 7, the next page. That now the explanation for the delay that has occasioned with effect from 1st/2nd 2022 till the filing of this appeal on 22nd 12/22, that is a delay of 325 days, as recorded as this second set of certified copy for the impugned judgment and order dated 22nd 11/19 was applied on 15/2/22, and the same was obtained by the appeal council on 18, which took around 63 days. However, it is further pertinent to mention here that there was a death in the family of the appellants for which he had to be out of station during the month of April, then thereafter, the memo there was some technical defect in the memo of appeal, which were corrected and sent to the regional office, and the same was vetted by the council at Guwahati in the regional office, and all this process took time for filing the memo of appeal. Then thereafter, at paragraph 8, I mentioned the division office at Shillong, on receipt of the memo of appeal, requested the conducting council to set the final draft, all appended annexes to it, and file it, and that took some time. And thereafter, I mentioned that during the month of October 22, unfortunately, there was an incident of accident with my daughter, and that also took some time. I have mentioned here. Then all these facts which has constituted after the disposal of the review, I have stated these facts constitute sufficient cause. So, my lord, I have here a case to be arguable case is there. The case has got its merit. In fact, there has been no willful negligence, nor there has been any deliberate on my part. My case, I have an arguable case, because principally what has happened that while calculating the quantum, the trial court has taken the gross salary income, not the net. That ought to have been taken. So that has been substantial variation in the quantum. And moreover, one more part is that, of course, if the delay is condoned, that is interest on the prospective income, ought not to happen. There is a judgment for that matter. And besides other ancillary issues which the court had failed to take into cognizance in passing the award, those things were not taken in this correct perspective. So I have an arguable case. So in fact, what I have stated in my petition for condoning the delay, these facts constitute, according to me, sufficient ground to the satisfaction of the court. My humble prayer is that the delay may be condoned and the appeal may be allowed to be registered and accordingly to be heard on merit.
May I please, Your Lordship? My learned friend has made a submission. Very conveniently, he has stated that this delay has occasioned, but it is not that easy, my lord. His grounds for condonation of delays are 3 in numbers. The first ground, my lord, is the time consumed in disposal of the review application. Second ground, my lord, is that the files were placed before different officers in different offices. That took time. And the third ultimate ground is his personal ground, counsel's personal ground. Now, all these grounds, my lord, does not constitute sufficient cause, which is the prime requirement of Section 5. Sufficient cause. Now, my lord, I will take your lordship to my reply. I have filed against the petition for condonation of delay, if your lordship will come. They have filed, my lord, a review application which was not maintainable. In the disguise of a review, my lord, they filed an appeal. They have taken the grounds in review, my lord. All those grounds were settled by the tribunal by duly appreciating the evidence. Review is only filed under...
We are not on the,
no, my lord,
the merits of the review.
Whether it is sufficient ground or not, my lord. Review is filed...
They have filed the review, rightly or wrongly.
Yes, my lord.
But the point is, the review was taken on board and it was finally disposed of.
My lord, there lies the...
For which considerable time has taken place.
Yes, my lord.
I think that can be accepted.
The question is that they knew very well that review does not lie.
It is not for you to...
Wasting the time. I have a judgment, my lord, of Tripura High Court in this respect. Your lordship, in similar situation where review was filed in MSC case and thereafter appeal was filed, what the court has said, if your lordship will come to second para, application has been filed seeking condonation of delay, of inordinate delay in filing the appeal, and the justification tendered in that against the impugn order award dated so and so where the tribunal awarded a compensation of so and so as advised, a review application was filed on such and such date before the tribunal, and that was rejected on such and such date, and immediately on rejection of the review application by tribunal by order dated so and so, the present appeal has been preferred, and in given circumstances, at least the delay deserves to be condoned. Indisputably, the review application was not maintainable, and the only scope available to the parties after passing the award by Motor Accident Claim Tribunal is only limited purpose for mathematical corrections if required under section 152. I have heard the counsel for the parties, and in entirety of the matter where the compensation is rupees so and so has been awarded to the injured claimant, and the incident relates to so and so, culminated into award so and so, even if there is some justification tendered in filing an appeal with inordinate delay, this court in totality of the matter is not inclined to grant indulgence in the condonation of delay. Exactly, my case falls within this, my lord. In that case also, my lord, they filed a review, and immediately after the review was dismissed, they came and filed an appeal. So review, my lord, is only permissible to correct mathematical errors, only the error apparent on the face of the record. They have taken the plea, my lord, which already settled by the tribunal, by duly appreciating the evidence, that 10 lakh amount, your lordship, it has come in the evidence that amount was given by the department concerned. That amount would otherwise have been receivable even if the person would have not died in the road accident. That is a matter of evidence, my lord.
Mr. Masuri,
My lord.
is the copy of the review application here?
They have
and also,
not,
what about the order passed in the review? Is it
they have not annexed, my lord.
Is there?
Well,
Well, it is not here. In this petition, it's not there. It is. We have annexed in the main memo, but in this, it's not there.
Main memo.
Yeah, it's not.
Anyway,
no.
You have a copy of the same?
Yes, I have, my lord. I have.
Where is it?
Because so far review was concerned, our principal challenge was regarding that amount of 10 lakh. But here, my lord, we are just before the condonation.
No,
so whether sufficient, my facts constitute sufficient cause for condonation. These are matters of evidence. Decide on merit.
This is the order of the review court.
Yes, my lord. This is at page 77, my lord.
Where is the copy of the review application? Reference has been made to the review application, and the orders passed thereon, which according to Mr. Mansoori is cannot be entertained by the court. So the court have a look at that.
My lord.
You have a copy of that?
But it is annexed in the. I can give the copy, but it is annexed in the. I can provide the copy.
No, annex here and.
No, it is not annexed here. It is not annexed here. But
you have to annex the order of the review report.
No. Because I would just like to read section 12 of the limitation.
What we can do? First, we'll deal with the objection raised by the respondent as to the review itself, whether it was maintainable or not, whether the court has rightly passed the order. So, in that respect, of course, this court will not sit in judgment over that.
That is a matter.
But the only thing is that since a judgment has been referred to this court, where perhaps you see the contents and the order of the review has been taken into consideration, looking into the issue of condonation of delay
My lord.
preferred by the appellant or by the parties.
Yeah.
So, in that case, for the sake of perusal of the review application, it will be better if this court gets a copy of it.
Well, I would just like to read Section 12 of the Limitation Act. So for this Section 12, to make the exclusion of time in legal proceeding, in computing the period of limitation for any suit, appeal, or application, the day from which such period is to be reckoned shall be excluded. In computing, second part, in computing the period of limitation for an appeal or an application for leave to appeal or for revision or for review, Section 12, subsection 2, or for review of the judgment, the day on which the judgment complained of was pronounced, and the time requisite for obtaining the copy of the decree, sentence, or order appeal from or sought to be reviewed, sought to be revised or reviewed, shall be excluded.
That I'm not
Shall be
challenging.
excluded.
That I'm not challenging also.
So
that is not my concern.
So far the review portion is concerned.
Yes, you see,
Whatever be the merit,
see, proceeding before a wrong
My lord.
forum, proceeding
Correct,
before
correct, my lord.
that can be excluded.
There
That
is-
time,
That way, I'm not also on that matter.
my lord, so far my friend has raised the issue that it was decided on merit, it was decided on so and so. That is a subject matter where this, as per the section, the review period is to be excluded. But now he's touching the merit. We are here before this court
My
for
lord, my
for-
only contention is
Yes, sir. We are here before the court to condone praying for continuation of delay, whether the facts stated by me constitute sufficient cause or not. If it constitutes sufficient cause, in view of the section 12, period of review to be excluded. So if he has raised those contentions, there is a question of merit.
period of review to be excluded. Where
Yes.
is it written? When filing an appeal,
My lord.
you're not challenging the
My lord.
review. You're challenging the award of the tribunal.
So we are challenging both.
No.
So as a matter
Where
of
is
fact,
it?
so
I have not
as a
seen that
matter
you
of fact,
challenged.
the period of review, that period of review which has taken sufficient time, it constitute, if we take that itself constitute a good ground.
No, that does not. Where is the law?
Because
You show me. That is what I want to know.
Because that itself,
Which law
because it
provides
is-
you?
we are going only on the aspect of sufficient
My lord,
cause.
Exactly,
only on
my
the
lord.
sufficient
That
cause.
is the point
Cannot enter into matter.
The applicant says that period
of review.
of review, which has taken considerable time,
Yes, my lord.
does constitute
Constitute
sufficient
a good
cause.
ground.
No,
That cause. Even if it is
that
taken
is- that's
for the
if it
sake
is,
of our
that
good.
is different issue, my lord. He says that the time consumed in disposal of the review can be condoned. That is a sufficient cause. No.
That
Where
can
it will be a
constitute- that
sufficient
constitutes a
cause only when the review was filed and review lied. There was no review, my lord. It was in fact an appeal filed
Whether it is
in disguise of a review.
Even then,
That has come.
even then, let's
See,
even then, you see,
my lord,
this court will
my
take,
only contention-
even then, this court will take it that the applicant or the petitioner for that matter, or the review petitioner for that matter, has proceeded before a wrong forum, for which considerable delay has occurred.
All right, then we fall back, my lord, on the other grounds.
Please
We fall back on the other ground.
Please continue.
The other ground, my lord, is the files being placed from one office to another, from one officer to another. That is also not a sufficient ground. On that point, my lord, I would rely upon a judgment passed recently by our Guwahati High Court, my lord. Just last month, your lordship, this judgment has come. I would take your lordship to page 5. Several judgments of Supreme Court, Apex Court has been dealt with in this case, my lord. If I take your lordship to para 24C, page 5, my lord.
(24C),
Yes, my lord.
para 24C.
24C, my lord.
Yes, only 15.
No, my lord, there is page 5, my lord. If your lordship will come to page 5. If your lordship has got,
This is not para 24, is it?
this is para, this says is para,
This
perhaps
part, this
11,
is part of para 10.
my lord, para 10, my lord.
Confusing the code.
My lord, I would like to come to this C, my lord.
Yes.
This is an apex court judgment which has been dealt in this case. There is a point beyond which even the court cannot help a litigant. Even if the litigant is government, which is itself under the shackles of bureaucratic indifferences, having regard to the law of limitation which binds everybody, we cannot find any way of granting relief. It is true that government should not be treated as any other private litigant, as indeed in the case of the former, the decisions to present the prosecute appeal are not individual but are institutional decisions, necessarily bogged down by the proverbial red tap. But there are limits to this also. Even with all this latitude, the explanation offered for delay in this case merely serves to aggravate the attitude of indifference of revenue in protecting its common interest. The affidavit is again one of the stereotyped affidavit, making it susceptible to the criticism that the revenue does not seem to attach any importance to the need for promptitude, even where it affects its own interest. Now that number D, my lord, it is an insurance company. Report so and so, wherein the Guwahati High Court has observed that the procedure of internal management of affairs, here exactly the same case, my lord, of the applicant company are not statutory procedures. And if the applicant advise a procedure of moving the file from one table to another, the applicant does so at their own risk. Honorable Court also observed that except in few cases, majority of the insurance claims are generally on preset pattern, and the applicant who are in the business of ensuring risk is supposed to be equipped with some sort of mechanism to calculate the estimated award accepted in a case, and as such it is for the applicant to devise a way and means to expeditiously challenge those awards to which they do not agree to. Now the next one, my lord, E, wherein the Guwahati High Court has referred to a judgment of Honorable Apex Court in office of the Chief Postmaster General versus Living Media so-and-so, reported in so-and-so, wherein it has held that the claim on account of impersonal machineries and inherited bureaucratic methodology of making several notes cannot be accepted in view of the modern technologies being used and available, and that the law of limitation undoubtedly binds everybody, including the government, relying on aforesaid ruling. Mr. So-and-so, learned counsel for the respondent number 1, has submitted that insurance company has taken the law of limitation for a ride in spite of being aware of the statutory period of limitation prescribed by law for preferring an appeal. And in the instant case, they have miserably failed to show sufficient cause for not approaching the appellate court within the period prescribed by law. Then finally, my lord, para 13. In this case, though the applicant has also taken the plea of national lockdown due to COVID-19 as one of the cause for delay, however, it is pertinent to mention that the national lockdown started on such and such date, whereas the period of limitation for preferring the appeal in the instant case expired much before the date that is so and so. The national lockdown started only after 36 days after a lapse of prescribed period of limitation in the instant case, and the applicant has not explained satisfactorily what prevented it to approach the court before imposition of national lockdown. It is an admitted fact that applicant is in the business of insurance throughout the country, and as such, it would be wrong to presume that it was not aware about the period of limitation prescribed under section so and so for preferring an appeal against an award passed by the claim tribunal. In the instant case, the period of limitation has been prescribed by the Statute of Parliament, that is Motor Vehicle Act 1988. The applicant, which is an insurance company and which deals with the business of insurance, is supposed to know the limitation prescribed for preferring an appeal against the award of motor claim tribunal in motor accident claim cases. It is also supposed to devise the internal procedure involved for taking a decision for preferring an appeal in such a manner so that in a case of a decision to prefer an appeal is taken, the same may be preferred within the period of limitation prescribed by law. It cannot take the statutory provisions of limitation for granted and give a total go-by to the period of limitation so prescribed by the statute. More so, considering the fact that Motor Vehicle Act 1988 is a beneficial and welfare legislation, In the instant case, the submission of the learned counsel for the applicant that for the time consumed in following the administrative procedures and for correspondence between the various regional divisional office of the applicant company, the appeal could not be preferred within the prescribed time of limitation, does not appears to be sufficient cause to condone the delay. Further, the submission of the learned counsel for the appellant that the delay caused was in view of circumstances which were beyond the control of the applicant is also not acceptable, as the internal procedures of the applicant company for taking a decision for preferring an appeal under Section 173 of Motor Vehicle Act has been devised by the applicant company itself, knowing fully well the period of limitation prescribed by the statute. When the applicant company has itself devised its own internal procedure, it cannot be said that the same was beyond the control of the applicant. Considering the period of limitation which was made available statutorily, the internal procedure of the applicant company ought to have been accordingly devised, so as to enable it to process a case and file an appeal within the period of limitation prescribed by the statute. Having regard to the decision of Apex Court, High Courts referred herein above, as well as for the reason mentioned in foregoing paragraphs, this court is of the considered opinion that the applicant has failed to show sufficient cause for condemning the delay in preferring the appeal in the instant case. Accordingly, this case is dismissed. So, my lord, this judgment covers the second ground placed before this honorable court, that the file was placed before the regional office to Guwahati, then it came back from there. So this case, my lord, covers that portion of my contention. The next, my lawyer friend has taken the plea that he had some personal difficulties. So I would rely, my lord, on a judgment passed by Delhi High Court, my lord. Your lordship may kindly come to para 2. This is just short judgment, where it is section 5. Your lordship can see if it is in the middle of the paragraph 2, the middle section 5. Your lordship can.
What was the earlier judgment?
The earlier judgment, my lord, was of Tripura High Court, and before after that, my lord, it was Guwahati High Court.
Just a moment.
Lordship will come to.
Second one is.
This is Delhi High Court, my lord.
Where is the citation for this?
My lord, Delhi High Court, my lord.
Delhi High Court, but it's not reported.
It's from the online, my lord.
You know, if you cite a case before this court,
my lord,
you should give relevant citation or.
I will try to take out if it is reported.
Could be SEC or SEC online, because sometimes these are difficult,
my lord,
to confirm. And this is a 2010 matter.
2010, my lord.
By now it should have been reported, and
I will just try to find out, my lord, if it is reported anywhere.
Yes. Please.
My lord, here para 2, if your lordship will come para 2 in the middle, where it appears section 5.
Yes.
Para 2 section 5, if your lordship has got that.
Yes.
Similarly, section 5 of Limitation Act does not envisage the inability of an advocate to file appeal due to his personal reason as a ground for condonation of delay.
Yes.
The insurance company could have contacted any other advocate available for filing appeal. In fact, the insurance company, even in this High Court, has many advocates on its panel. If one advocate is ill or his mother was ill, any other panel advocate could have filed the appeal or a new advocate could have been engaged. I therefore find no force in this application for condonation of delay. The application is hereby dismissed. Since the application for condonation of delay in filing appeal has been dismissed, this appeal is barred by limitation and hereby dismissed as such. So, my lord, the third ground also, on the personal ground that why he was prevented from filing the appeal in time due to his personal reason, that also, Your Honor, is not a sufficient ground for condonation of delay. So all these three grounds, my lord, right from the ground number one, that is time consumed in disposal of the review when review was not maintainable only, yet they filed the review and it got ultimately dismissed devoid of merit.
Yes.
That time also is not as consumed, is also not a sufficient ground for condonation of delay. And this office movement of the file in the office from one headquarter to another is also not a sufficient cause, and so also the personal ground of the counsel is also not sufficient cause. So I pray, Your Honor, that since the condonation petition, Your Honor, it's devoid of merit, the same may be dismissed and appeal also may be dismissed on that ground alone.
So, anything else?
Well, my only thing is that the
Sufficient cause has been shown.
That is the whatever judgment he has cited, maybe those judgments, of course, are not reported, and many judgments which he has. My only thing is that ultimately it depends on the facts and circumstances of an individual case. Facts and circumstances of the individual. These are just reference, time and again, because government delays at many point of time. So court from time to time passes the orders.
You can also cite some
yes,
authorities. Why you have to be,
so,
you should have been prepared.
Yes.
You should have been prepared. He has come prepared.
Yes.
What about you?
I'll find it.
Now you're saying yes, the matter is already heard.
So far my situation was concerned is that the facts which I have stated, whether they constitute sufficient cause or not. So if the court examines objectively,
that the court will take into account.
That's right.
Your submission will take into account. But
nevertheless, even if the court wants judgment, let this matter come up next week. I'll just.
If you want to, support your contention with the authorities, you should have done it.
Let this matter come up next week.
So tomorrow?
No, not tomorrow. Let it come up next week. Just or day after tomorrow.
Heard learned counsel of the parties. However, the learned counsel for the applicant, public insurance company, has submitted that he may be allowed to produce relevant authorities to support his submission. As prayed for, this is matter to 1 week.
Item number 3.
May please, Lordship, Lordship, I am praying for some more time, Lordship, to file my rejoinder.
I think this is only about the notification, isn't it?
Yes, Lordship.
Then what rejoinder is required? Facts, I don't think are disputed.
Absolutely same as the other repetitions.
In fact, this would be an extension of the other one.
In fact, that is the case.
The counsel for petition has submitted that some more accommodation may be allowed for the joint affidavit to be filed, so as to afford equal opportunity to all the parties involved. The prayer is allowed. Let the rejoinder affidavit be filed within the next date fix. This is matter after 2 weeks.
Fully obliged.
Item number 4.
Lordship, we're supposed to file a rejoinder.
Yes. Have you done it?
No, Your Lordship, some more time.
Then counsel for the petitioner has sought for some more time to file the rejoinder affidavit. Pray aloud. This is matter of the 3 weeks.
Item number 5.
May it please your lordship, as per the last occasion, my lord, your lordship has directed both the parties in order to file a synopsis of written argument, my lord, will be filing a written.
Same, your lordship. We'll be filing the written synopsis.
Parties have filed their respective written argument. Matter is now posted for judgment.
Much obliged, your lordship.
Item number 6.
Please, your lordship. Lordship, notice has been received as per the report we have gotten from the post office, lordship. However, at the very outset, lordship, I beg to just maybe by way of a reminder to this honorable court that your lordship had recused yourself from the other matter, SRGT, lordship. So this is the criminal petition attached to that.
This is a contempt petition against the violation of the order.
Place this matter before any other court except this court.
Much obliged, lordship.
Item number 8.
Yes, where were we?
I'm for the petitioner, Your Lordship.
Have you?
Lordship, if I may be allowed to file my additional affidavit, Your Lordship. I filed the petition to allow me to file additional affidavit, Your Lordship. In 80.
Have you made any prayer for that?
I have to. Your Lordship, in proper you have to file. They still not accept if the code is not passed order, Your Lordship.
Additional affidavit for what?
To bring this additional documents, Your Lordship.
Oh, additional documents. The counsel for the petitioner has submitted that he may be allowed to file an additional affidavit to bring certain relevant documents on record before this court. It may be noted that the case is a long pending one. However, for ends of justice, the prayer is allowed. It is made clear that the petitioner shall file the said affidavit within the next date fixed, with prior intimation to the respondents herein, who, if so advised, may file a rejoinder. After which, no more proceedings shall be allowed in that regard, and the matter will be will be heard finally. So you've understood? Let him file, you reply, and matter ends there. No adjournment, matter will be heard. This is matter after 3 weeks.
The misapplication 82 is disposed of.
82 of 2013.
Oh, that is in the misapplication?
82 of 2023.
Accordingly, misapplication also is hereby disposed of. The main case without release after 3 weeks.
Item number 10.
I'm praying for some time, my lord. Mr. Paul had to leave, my lord. He was here. He had to leave for some urgent work, my lord. Fix it after a week, my lord.
Your Lordship, meet please. As per order dated 7/3/2023, Your Lordship, it was passed that no further adjournment should be given. It should be definitely be taken up.
This matter has been heard?
My lord, this matter has been heard.
Now again, you see, once it is heard in part, then for the matter to be restarted again becomes difficult for this court to.
My lord, may fix a short date, my lord. Next week.
We'll do it on Monday then. Accommodation has been sought on behalf of the petitioner on the ground that the learned senior conducting counsel is indisposed. In spite of the fact that the court has insisted that the matter be heard expeditiously, however, on ground of personal difficulty being advanced, the same is allowed. It is made clear that no further adjournment will be allowed in this case. This matter on 19. Monday is 19, isn't it?
Yes.
This is matter on 19.
Hello, Branch.
Item number 12.
Yes, Ms. Hakim.
Lordship, we're still waiting for the settlement deed. They haven't signed in the settlement deed.
Have you read the last order?
Yes, Your Lordship. But we have done with the payment and all. We already give them the money, but they haven't signed.
You're for the appellant?
Yes, Your Honor.
The appellant is present, however, the respondent is not represented. On pre-meet with the appellant, list this matter for hearing after 2 weeks.
Item number 13.
Please, my lord.
Yes.
Well, as per your order, my lord, we have filed the reply to the affidavit filed by the state.
My lord, now it may be reserved for judgment, my lord.
What?
My lord had already heard, and from the original records,
No,
we
no.
have
What is this affidavit?
affidavit is in response to the affidavit which we filed, bringing on record the copy of the award and the award statement. So, in response to that, the petitioner has submitted this additional affidavit
My lord,
of reply.
Take you back, your lordship. So what is happening here, my lord, is that the initial period, my lord, when your lordships are directed the state respondents to produce the records, despite several occasions, no record has been produced. But subsequently, my lord, when the matter has been eventually heard, and the parties are directed to file their respective written submissions, they have filed an affidavit bringing a record these documents. Firstly, that is the award statement as well as the notification by the government. Now, my lord, here we have filed a reply. Though there's an award has been made, but the question remains, my lord, that no notice nor a copy of the award has been furnished to us in terms of section 12.1 as mandated by law. Now, my lord, here
But
first our consideration-
that contention would be included in your main
written argument.
main
My
application.
lord, now here, my lord, what is that? Let the matter be fixed next week, my lord. Only on this issue, my lord. Small hearing.
On prayer made by the petitioner, this is matter of the
And in
2
the
weeks.
meantime, my lord, they can file written submissions.
I'll give you 2 weeks.
Conclude it, my
2 weeks time, and we'll see.
Item number 14.
May it please your lordship, I pray for an adjournment in this matter, my lord.
Have you sought the consent of the other side
Yes, my lord.
on prayer made by the respondent? Who has submitted to Miss K. Gurung London Council? Stating that the consent of the petitioner has been sought for in this regard. The matter is adjourned. This is matter of the 3 weeks.
Much obliged, my lord.
Item number 15.
What is left here?
My lord, this is a criminal revision petition, a lordship will remember. On the last occasion, the passport of the petitioner herein was called for to be produced.
I have produced the passport and visa.
So this is only with regard to that seal, whether it was forged or not.
Lordship, yes. No, but that has been decided by the London Trial Court.
Oh, that is
Already decided.
It is a fake visa.
Yes,
Second, there are two extensions. The first extension is okay, it's in order, but the second extension it's a fake one. The
Well,
seal is fake.
This is completely misleading. May I, Lordship?
So, Mr. Guru, we'll complete the hearing today then.
Yes, sir.
So we'll take it up after lunch. Yes.
May I please, your lordship, your lordship, in this matter, I will pay 2 weeks' time, your lordship, to go through the inspection records.
What matter?
Lordship.
In this,
My lord, this is a case, Lordship, where the petitioners are being tried before the Juvenile Justice Board.
no, what you're referring to? Which case, Miss? This, item 16. Oh,
16 and
should have
17.
made. We were on the other case just a while ago. I was about to rise, then you. So,
She's
tell
taking
me,
time.
tell me.
Seeking time.
You want time?
Yes, your lordship.
On pre-made by the petitioner, this is matter of the 3 weeks.
Deeply obliged.
Anything else?
Lordship, in that case, Lordship, if I may, my item number 15, let it come after a week, Lordship.
Oh, 15.
I'm ready in the second
I'm
half
also
also,
ready.
Lordship.
But,
Because this matter has been adjourned time to time.
Then
I
we'll
have
take
submitted
it up.
my material exhibit also long time back.
Then we'll take up after second half.
Second half.
So I'm ready, sir. Now it's up to my
No. Since
friend,
there is an
colleague.
objection.
No, I'm not objecting.
Fine.
Yes.
Deeply obliged.
Lordship, for supplementary item 80, Lordship, the doctor counsel is not available, Lordship, in the second half, so pretty matter may come out tomorrow, Lordship.
My lord, let it come up after 1 week, my lord. We are waiting, and even his seniors, my senior counsel also has. He was waiting all along, and it was called for the
After a week, Lordship.
After a week, my lord. It's relating to the removal of the hoardings.
On pre-made by parties, this is matter of the 1 week.
Obliged.
Second half.
May it please your lordship, I beg an apology for not mentioning this item earlier, my lord.
Item?
Item 19, my lord. I pray for some accommodation in this matter, my lord.
My lord, I am the petitioner here. My lord, this matter is fixed in the lower court on the 26th. Just a very small question of law is involved.
Item 20?
Item 19.
Or 19?
A very small question of law is involved, my lord, whether the sanction given by the registrar of Nehu is valid in the eyes of law. So argument will not even take half an hour. So my lord, if I may brief, the matter can be taken on Tuesday. I've already told my learned friend from the other side, and I think she's okay with it. On Tuesday only, since they are seeking an accommodation today.
On premiered by the parties, this is matter on 27th, 28th, 28th.
Obliged.
Second.
Yes, Mr. Guru.
Second call, item 15.
15.
This one, my senior, due to some personal difficulty, can you kindly fix tomorrow, Your Honor? Your Lordship?
On premiered by the petitioner, this is matter after 2 weeks.
Item number 18.
Last occasion, this matter was hardly loaded.
Excuse me. But Mr.
Debnat.
Where's Mr. Debnat?
He's the Union Government Council, Lordship, but he's not there. He's not there in this room.
What is this? The council have come all the way from Guwahati.
Yes, Lordship.
That courtesy should be there. He was here earlier.
He was here.
If he is not ready to take up the matter, he could have requested them.
Yes, Lordship. He's not there in that room.
I told him to wait, but he left.
This Union Government matter.
No, because this is a private matter.
Union Government.
Part
No, not
there
union.
is no private party.
Okay.
Debnat is not comfortable with private cases. So, what do we do, Miss?
Lordship cannot wait also.
We cannot.
Lordship may be fixed on next Tuesday, the first item, because it is partly hard. That is why maybe fixed item, number 1, in hearing.
Yeah, Tuesday is okay with you?
Tuesday, 20th. Last chance, Lordship.
Then a counsel to the petitioner is present. However, then a counsel to the respondent is absent. As prayed for by the petitioner, this matter is adjourned for the day. List the same on 27.
28, Lordship.
28.
20.
Oh yes, sorry. 20, 20th. तो मैंने already 20th नहीं. 20th as first item in the hearing list.
Obliged. It may, part heard may be shown as.
Part heard. It is only part heard.
Yes, Lordship.
Item number 20.
Please, Your Lordship. Your Lordship, I pray for 2 weeks' time,
So,
Your
Guru,
Lordship.
what happened to you?
Lordship, I had gone for lunch, so I came running.
Somebody said that you have gone out or somewhere.
No, I had gone out for lunch, a quick lunch. As it,
Your colleague has mentioned that you have.
I did not give any instruction, but however,
I have adjourned that matter. So,
Your Lordship, I pray for 2 weeks' time, Your Lordship. This matter.
on prayer made by the petitioner, this is matter of 2 weeks.
Highly obliged.